All right, this is case number 234968. This is Bernard Street Apartments versus Samuel Lindale, and occupants of property at that location. The court also calls the suffix 9682. That's Young Maynard versus Trey Cuff and other occupants of property at 2500 West Grand Boulevard, number 1013. The court is calling the suffix 9685. That is Bernard Street Apartments versus Jacqueline Carruthers and other occupants of property at 641 Bernard Street, unit number 1506. Your appearance at this time, counsel.
Yes, Steve Gann, P78209, appearing for plaintiff in all these cases. At this time, I believe we just have one that's still going to be going. I'll double check with my staff, but they only gave me one case for your 140 call. I've got a couple more coming up 2 hours from now.
Yes, sir.
But
So,
this,
which one survives in this group? Sort of last four.
9682, Your Honor, that would be Young Manor versus a Trey Cuff.
Thank you. The other two matters are dismissed. Is that correct, Mr. Gann?
That is correct.
All right. The court will place a notation on those two files that they are in fact dismissed. With regard to the Trey Cuff matter, do I have Trey Cuff or any person living at the West Grand Boulevard apartment 1013 on the Zoom? If so, say something at this time. Right. It looks like this is the first hearing regarding this matter, counsel. Accordingly, I will set the matter over for the next action date. That date is going to be the 12th of February, 2/12, and that's going to be at 10 o'clock a.m. 2/12 at 10 o'clock a.m. If the defendant does not appear at that time, the court will at that time entertain a motion for entry of default judgment. So ordered at this time.
Thank you so much, Your Honor.
Thank you, counsel.
And I do have a couple more at 240 for your docket. I have that, actually got 240 in all four courtrooms. So I'm going to be bouncing back and forth. So I hope I don't delay you too much at that
All right, I
time.
do see that there are two matters. Are those matters dismissals, or are they matters that are going forward? What's the nature of those, sir?
They're both, I believe, going to be first hearings. They both are still going, and my clients are willing to wait for EDP 2.0.
All right, very well. We'll address those at the appropriate time.
Thank you, Your Honor.
See if I had them. So they're not that stacked. We don't have them. This as a sheet, this is all care for today. For the afternoon. So those they aren't there. That means those files aren't theirs. They're on the register for today. So in this one, 712. I might have given you this one for day left for 712. This is the dismissal. You might have to file, but they just said dismissal for that.
All right, Mr. Vidani. This is case number 2349-689. This is Mutual Property Management versus Tammy Harris and other occupants of property at 19399 Waltham. The court also calls 9693. That's Mutual Property versus Trina Hughley and other occupants of property at 9388 Hayden Street regarding the suffix 9697. That's NBA Management Detroit versus Barnabas Robbins and occupants of property at 3266 Pasadena Lower Unit. I see that Mr. Vajami, Eli Vajami is now assumed his P number is 74626. I understand he's in another courtroom. At this time, do I have on the Zoom Tammy Harris? If you're on the Zoom, please say something at this time. All right, I'm inquiring now in 9639. Do I have Trina Hughley on this Zoom? If
Yes,
so,
you
please.
do.
Where are you? All right, thank you, ma'am. I see you now. Just hold one moment here. I'm checking now on 9697. This is Barnabas Robbins regarding our property at Pasadena, the lower unit. If you're on the Zoom, please say something at this time.
Yes, I'm on the call.
All right, Mr. Robbins, I do see you on this call. With regard to the subjects 9689, I'm going to set that matter over for a second hearing on the 12th of February 2021. That hearing is going to be at 9:45 a.m. Defendant did not appear on this matter. And the second hearing, the defendant does not appear. The court will entertain a motion for entry of default judgment. Just one moment. And regarding the suffix 9693, and good afternoon to you, Ms. Hughley. You have you had an opportunity, ma'am, to speak with a lawyer regarding the matter that you have before the court?
I did at one point. I'm talking with Detroit Evictions. They told me to attend the hearing and they'd be in contact with me, but I haven't heard back from them.
All right, ma'am. All right, so what I'm going to do, ma'am, is I'm going to set it up now for you to talk with a lawyer today that will be able to give you some advice and information regarding the matter that you have before the court. Under the Supreme Court's administrative order, this first hearing will be adjourned until the subsequent hearing.
Where's she at down here?
I'm
Cynthia,
sorry.
the
I
128
can't hear you.
Just one moment. Just one moment. Just one moment. All right, thank you, and pardon the interruption, ma'am. That date is going to be the 18th of February, 2019, at 9:30 a.m. That's when you will zoom back in to the courtroom, February 18th of 2021. February 18, 2021 is also going to be the date for Mr. Robbins, Mr. Barnabas Robbins, under 9697. That's the date you'll come back into the zone, February 18th, 2021 at 9:30 a.m. Both of you, I'm going to give you an opportunity to speak with a lawyer in a breakout room. So I'm going to identify someone that will be able to talk with you and go over what your rights are and give you the information that you need for the next action date. You understand that, Ms. Hughley?
Yes, thank you.
Thank you. And you understand as well, Mr. Robbins, sir?
Say it again, sir.
You understand what I just, the information I just went over with you, sir?
Yes, sir. You said February 18th at 9:45 in the morning.
I said 9:30. That's pretty close. And I'm going to give you a lawyer to talk to now, because you haven't talked to a lawyer regarding this matter in the past. Is that correct?
No, sir, I have not.
Okay. All right. So I'm going to give you someone in just a moment. Who's available to talk to Ms. Hughley at this point?
Your Honor, this is Indra Pandiraj from Lakeshore Legal Aid. I can speak with her.
All right. All right. Attorney Indra is going to speak with you, Ms. Hughley. I'm going to put you in breakout room number 1, and Ms. Indra is going to that breakout room as well. And you'll be able to talk about your legal matters. You already have your date. So once you're done in the breakout room, you're free to go, and I'll see you on the next action. Good day to you, Ms. Hughley.
Your Honor, I would also request Rima Hathwari to be added to the breakout room.
You're breaking up a little bit, Ms. Indra. Who else is that?
Ms. Rima Hathwari from Lakeshore Legal Aid to be added to the breakout room.
All right. I sure will. And I'm sending you a notification right now, Mr. Kakari. Good day to you. All right, who's available to speak now with Mr. Robbins? Mr. Robbins, I want to put it in a breakout room. Who's available?
Your Honor, I'm available. Josh Ronenbaum from Lake Shore Legal Aid.
All right, thank you, Mr. Ronbaum. I'm going to send you to breakout room number 2. And Mr. Robbins, you'll be speaking with Attorney Ronbaum in breakout room number 2. You'll receive a notification in just a few seconds here. There is your notification, Mr. Robbins. And Mr. Ronbaum, I'm sending you there as well. There is your notification, sir. All right.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Same day to return on both of these.
Okay.
Did I drop something?
Oh, no, I didn't.
All right, this is case number.
Oh.
Thank you.
Oh. Hey, oh, you got one? Okay.
All right, thank you, I appreciate that. All right, this is case number 2347060. This is Rika Cosma versus Demetra DJ, and occupants of property located at 19170 Yonker in the city of Detroit. The matter is before the court on the filing of a complaint for recovery possession. Records should reflect the complaint in this matter is filed on July the 23rd of 2020 due to the court's shutdown, et cetera. The matter was not heard until recently, and the court adjourned it over for the second hearing date pursuant to the administrative order of the Supreme Court. Right, you are your name then, for the owner of the property. Say your name for the record, please.
Viorica Kasma.
All right, thank you, Ms. Cosman. And is there an appearance for the defendant in this matter?
Yes, Your Honor, Andrea Enright, P70981, and Ms. Taylor is also on the call.
All right, good afternoon to you, Ms. Taylor.
Good afternoon.
All right, so it has Demetria DJ, but I believe that your last name is in fact Taylor, correct, ma'am?
Yes, correct.
All right, very well. You live at the property on Yonker Street, is that true?
Yes.
All right, counsel, Ms. Enright?
Yes, Your Honor. At this,
Go
I'm
ahead,
sorry,
ma'am. Sorry.
my apologies, Your Honor. At this time, I'd actually like to move to dismiss the plaintiff's complaint. This is based on a notice that was served, a notice to quit that was served on May the 28th, which was within the period of time where we had a statewide eviction moratorium. So she served it on May 28th. The expiration was June the 29th. Both of those dates were within eviction moratoriums that were set by the state of Michigan. First one was Executive Order 2020-85. that established the eviction moratorium for the state as a result of COVID. As Your Honor knows, this was in effect during that period of time. The court was shut down for a large period of that time. With the orders are to be construed broadly to effectuate the purpose of keeping people in their homes during the pandemic. The filing stems from this improper notice that was during that time frame, and the court's own statements about the executive orders also indicate that no demands for possession or notices to quit could be served during that period of time. So I would ask that it be dismissed based on that purpose.
No.
Ms. Cosmo, do you understand what's going on here, ma'am?
Oh, that's not the way it should be, because it was not about the COVID. This was about something else. And the whole thing, it was about not COVID. Her lease was terminated a long time ago, and she didn't move, and she didn't want to comply with none of my requests.
You understand that there was a period of time in which the law and the emergency orders that were entered by the state and various orders that were entered by the local court did not allow individuals to file any complaints regarding the removal of people from dwelling places during a set period of time. And so any complaints that would have been filed or any notices that would have been given during that time, those notices are avoidable or are in fact void. They have no impact and they do not give you the ability to come to court. So what happened is that in your case, you filed you served your notice during a time when the court was shut down, and more importantly, during a time when there was a order in place that prevented you from bringing or giving notice in a case involving residential tenancy. You could have still came and brought an action against someone, given a notice to someone living in commercial or someone with commercial property, such as operating a party store or something. But if it related to someone living in a house, in a dwelling place, during that time, the emergency order said that you could not give a notice terminating a person or evicting a person out of the property during that time because there was a moratorium on giving notices. There was a moratorium on filing cases based upon giving that notice. So you gave the notice during the time that you could not lawfully give a notice. That's the issue that Ms. Enright is raising. The last time that you were here, I did not know that was an issue in this case because I had not looked at the notice. But you could have filed, for example, in January or February last year. I think you could have filed as late as March. But during the month of May and June, you were right in that period where the law would not permit you to give a notice. It would not permit you to start this case. And that's the period of time in which you started it. And I understand that you were not aware of that, but once that information is publicly disseminated, then everybody is put on notice whether they are aware of it. In fact, just the fact that it was publicly put out there gives you notice. And so the problem with this case is that you don't have the right, or you didn't have the right to give that notice, and we cannot go back retroactively and fix that. Go ahead, Ms. Coleman. I'm listening to you. Yes, ma'am.
Can I say something, Your Honor?
Yes.
The paperwork was served in October sometime by the court server, and over there in that time it was served again. The notice was served again, and it was legal that time.
Yeah, the notice that was used to in fact start this case is a notice on the 28th of May of 2020. That's the notice that's used to start this case.
Yeah, but it was served again.
Yeah, but if you served another 30-day notice in October, you have to start a case based upon that notice that you served. You can't use the old notice. This case is based upon the notice that was filed during the month of May. And that notice, you couldn't file a notice. You couldn't start a notification in May of 2020 because of the emergency orders that were in place.
Okay, Your Honor, I just want to ask you, in that time, during even the moratorium was supposed to be for non-payment of rent, but not for ending of a lease and for life-threatening situation.
There were situations that only applied at various times to non-payment cases. And then there were rules that were released that applied to non-payment and termination cases. And the notice, the giving of a notice to evict a person from a dwelling place, there was a moratorium, a stopping of that, a non-allowance of that during the time that you submitted this notice. As it relates to the emergency complaints, there was an ability that was given for individuals to bring an emergency action where they believe that there was persons on the premises causing physical harm and causing permanent damage to the property. Those type of actions are different from the type of case that you brought. You brought a case to terminate tenancy, and you have the right to certainly file such a case where the law permits you to do so. The problem here is that at the time that you gave this notice, there was an emergency order in place that said that you could not give a notice. And that's the problem in this case.
Okay, Your Honor, can I
Yes,
say
ma'am.
something? I understand about the notices and I just was supposed to be noticed by the court and told a long time ago that I need another notice or another something, because like I started this case just in the hope that I can finish it. And I even left you a message in January 15. But Your Honor, I have a situation of life-threatening from this person that she moved in. And I filed a police report, and he said he wants to get me. I mean, that's not something that I should experience.
You're absolutely right. And you have the right under law, if you wish to do so, to bring an emergency action that sounds in health hazard, that there is something that is illegal going on, or there is something that is destroying the property, or if there are threats that are directed to you. That's a different type of case that you bring. And you can certainly file that type of case if you wish to do so. And at this season, you can file any kind of case that you want to and give any kind of notice that you want to, because there's no longer a moratorium on giving a notice. So that there was a moratorium on that during the time that you filed a notice in this case. So this case, what has to happen here is that this case has to be dismissed because the notice is in effect. The notice, under the law existing at the time, the emergency orders, you could not properly bring an action. That does not prevent you from bringing a subsequent action. It does not prevent you from bringing a matter before the court on an emergency basis. That's up to you. You have to be in control of those things. And when you file something in the court does not always look sua sponte or look of its own at whether or not you did it the right way. Oftentimes things are not done the right way, and it's only when someone brings that to the attention of the court, an attorney or some other person identify that, Judge, there was something improper about this, that it can properly be raised before this court. When you file the paperwork, it comes up before me. The immediate presumption is that everything is in good order. When a lawyer takes a look at it and they see that something is wrong, then they bring that to the attention of the court. And that's an appropriate thing to do. That's what has happened here, is that it's been brought to my attention in this case that the initiation of this case, that is the initial notice of termination, was given at a time that was not permitted by the emergency orders in place at that time. And that the whole case then is based upon that notice. That notice was not permitted by law, and therefore this case has to be dismissed. That does not have a prejudicial dismissal. You could bring another action if you choose to do so. I do wish you well, ma'am. This case is dismissed.
Thank you, Your Honor. Would you like me to submit a dismissal or should the court prepare one their own?
That would be good if you could shoot one over. All right.
Will
I
do,
wish you
Your
well,
Honor.
Ms.
Thank you.
Ms. Coleman. I wish you well,
Your
Mr.
Can I have Miss Andrea phone number?
Miss, okay, Miss Enright, Ms. Cosmo is saying she'd like to talk with you. She can't represent you because she'd have a conflict. She's representing the other side of this. Ms. Enright?
No, I just wanted some details from her.
I missed that last part. What did you say, Ms.
You said you
Cosmo?
just wanted what, ma'am?
I just wanted some details to talk to her about. And can I have your phone number, Miss Andrea?
I'll shoot you an email that has all my contact info, so you have my phone number, email, and
Okay,
we can
thank
we
you.
can go about it that way.
Yeah.
All right,
Thank you.
sounds good. Thank you. Good day to you, ma'am.
Thank you, Your Honor.
Thank you. Thank you, Counsel. Mr. Katz, Ms. Martin, Mr. Gaelic,
Minded, careful. We don't have to listen. That'd be-
and ma'am, there on the iPhone, what's your name, ma'am? Yes.
Jessica.
I wasn't talking to you, but I'm glad to hear your name. I was talking to the other young lady. So Jessica, is that Jessica, what's the last name?
Stokes.
What did you say that last name was, Jessica?
Stokes. Stokes.
Okay. All right, and I've got your name in there now. And which case are you on? Do you remember, do you have something with the last three digits of the case that you're on?
My case number is 420349077.
Her name Carmen Rambo.
What address are you at?
690 Brainerd.
That's the only case number. What's the case number again?
203449677.
It was today, but someone adjourned it. Oh, I guess that's when Tammy was here. It's for March the 22nd at 8:30.
All right, so your case has been adjourned until March the 22nd.
Which courtroom, do you know?
Lesson 10 down. So yeah, I'm looking at, this is case number 2349677, Brainerd Street
Doesn't
Apartment.
sound right.
Yes.
No.
And other occupants, apartment number 404, 690 Brainerd. It says that the case was set over. Well, it does have today's date on it, 1:30. Then it has
It's adjourned from there today.
it's adjourned from that date.
Mhm. It was in there. I don't know. It says 124. That isn't us. Her name is Jessica Stokes. That's Millhouse. That's why.
Oh, this belongs in another court.
Judge Millhouse, you said.
So you're in the wrong courtroom. You have to zoom into a
They gave me two different Zoom meet numbers.
yeah.
Instead of 432, it's going to be 433.
So look at your Zoom and do the 433. Okay, because yes, the judge is right next door. The other judge, Judge Millhouse. Okay, you see
Okay,
it?
thank you.
All
Hold on
right.
1 second. Thank you.
All right, good day to you, man. All right, and I'm trying to discover who the young lady is here.
Danielle
You,
Douglas.
ma'am. All right, thank you, Ms. Douglas. And
Your Honor, I'm on the Danielle Douglas matter, and we have submitted, I think Ms. Enright is as well. We've submitted a conditional dismissal in that case, Your Honor.
all right, let's go to that now. This is case number, just one moment. Case number 2349724. That's Jesse Bale versus Lakeisha Hardy. And then I also have, just 1 second here. I know I had another case for you. Yeah, I have 203491716. That is AHH Properties LLC versus Danielle Douglas. I also have the suffix 9720. That is All-in-One Management LLC versus Cassandra Maria, and occupants of property at 6403 Westwood. The Douglas property is on Piedmont. Your appearance on these three matters, Counsel.
Your Honor, I only have two that I know of, but my name is Dennis Flesland, P30289, appearing on behalf of All-in-One Management and AAH Properties, standing in for Mr. Sagati, Your Honor.
All right. I have another file here, although I do not have an appearance in it. The first one I called, it has Mr. Sagati's sticker on it, but it doesn't have his appearance. So I'll stand down on that one. That's the suffix 9722. That's a, who's got the baby background? All right, Ms. Enright, your appearance, please.
Good afternoon again, Your Honor. Andrea Enright, P70981 from Ms. Douglas, who is on the call as well. I think that's suffix 716.
All right, thank you, Madam Counsel. And so what's going on here? I understand that you may have reached an agreement in this regard.
That's correct, Your Honor. I had emailed the conditional dismissal to Mr. Sagati yesterday. I got it about 5 minutes ago. So my client and I have to sign it, and we'll submit it to the court for entry.
That's correct, Your Honor.
All right, sounds good. And Ms. Douglas, you understand what's going on?
Yes, sir.
All right. All right, so I'm going to go ahead and await the conditional dismissal. Once that's sent to me, this case will be dismissed based upon the conditions set forth in the written document. And I wish you well, Ms. Douglas. Good day to you.
All right. Thank you so much.
Thank you, Your Honor.
Thank you, Judge.
Thank you. And Mr. Flesland, regarding the suffix 9720, do I have Ms. Cassandra Maria on this Zoom? If you're here, please say something. Live at the property on Westwood. Anybody connected to that, say something now. All right. This does appear. Do you have this as the first hearing? I believe it is.
This is the first hearing, yes, Your Honor.
All right. All right, so I am going to go ahead and schedule the second hearing on this matter. Inasmuch as it appears the defendant has not appeared in this matter, that hearing will be set on the 12th, 2021, February 12th. That hearing is going to be set at 9:30 a.m. If the defendant does not appear at that second hearing, the court will entertain a motion at that time for entry of judgment by default, so ordered.
February 12th at 9:30, correct?
That's correct, sir.
Thank you, Judge.
Right. Yes, sir. And Mr. Vajani, I did call your matters, and they are the suffix 9693 and 9697. And in both of those matters, well, I should say in 9697, Barnabas Robbins did in fact appear, and he was connected to legal counsel, and the court went ahead on those matters and set them over for the 18th of February 2021 at 9:30 a.m. Also, with respect to the suffix 9693, Trina Hughley did appear, and as such, the court connected her to legal counsel, and she spoke with legal counsel, and the court set the matter over for 2/18/21 at 9:30 a.m.
Thank you very much, Judge. I just have one more case before you with the suffix 689.
Yes, and I knew that there was another one.
680.
I think that person did not appear, and I set that one for the 12th of February at 9:45. They did not appear, and I indicated on the record if they did not appear on the 12th, the court would be inclined to entertain a motion for entry of judgment by default.
Your Honor, just to repeat that, you said February 12th at 9:25, is that correct?
And,
Yeah,
9:45. February 12th, 9:45 a.m.
Excellent. Thank you very much, Judge. That resolves all my matters. I'm sorry I couldn't be here. I was in a different courtroom.
That's no problem. I would have waited if there were some challenges that were coming up, and given that they were first hearings, the court was able to move things along. So thank you.
I appreciate that, Judge. Have a good day.
You too, sir. All right, I'm seeing a Jesse Bell. Please identify yourself, the cell phone there, device. Jesse Bell, who are you, ma'am? You're muted, so I need you to come off. You're muted, so come off mute so I can hear you.
I'm sorry. Yeah, I don't see that the tenant is here.
Good afternoon to you.
Good afternoon.
What is your name?
I could barely hear. My name's Jessie Bell.
All right, and are you a tenant or you property owner? Why are you in my zone?
Yes, I am the property owner, and Lakeisha Hardy is the tenant that I was I'm attempting to evict.
All right, so that would be case number 23-49724, Jesse E. Bell versus Lakeisha Hardy regarding property at 16520 Normandy Street in the city of Detroit. The matter is before the court on the filing of a complaint for non-payment of rent. All right, thank you, ma'am. Do I have on this Zoom Lakeisha Hardy? If you're on the Zoom anywhere, ma'am, please say something.
Yes, I'm on here.
All right, thank you, Ms. Hardy. You live at the property on Normandy, is that correct, ma'am?
Yes, sir.
All right, thank you. Ma'am, have you had an opportunity to speak with legal counsel, a lawyer regarding your rights in this matter? And
no, sir.
Let me finish. And opportunities that there may be to resolve the matter that you have before the court. And I believe you indicated that you have not. Is that correct?
Yes, sir, I have not.
All right, ma'am. So what I'm going to do, this is the first hearing, and I'm operating under an emergency order, Ms. Hardy and Ms. Bale. That emergency order says that first hearings are adjourned, that I'm going to give a subsequent date. And so that's what I'm going to do in this case.
Your Honor, my counsel just connected.
All right, you didn't tell me that you had counsel. Who's representing you?
Yeah, Joseph Dillard.
All right, let's let Mr. Dillard come in.
Good
afternoon, Mr. Dillard. Your appearance regarding Bale versus Hardy, sir.
Yes, Joseph Dillard, P37225 on behalf of Ms. Bell.
All right, thank you, Mr. Dillard. This is the first hearing in this matter, and Miss Lakeisha Hardy is on this Zoom as well, the tenant in this matter. And I indicated that under the emergency order of the Supreme Court, I'm setting the matter for a second hearing, as is my duty to do so. That second hearing date is going to be the 18th of February, 2021. And that's going to be at 9:45 a.m. I'm also going to give Ms. Hardy an opportunity to talk with an attorney, as she has the right to counsel in this environment based upon the current state of affairs. So I'm going to send her to talk with someone in the breakout room, and then everybody will have the date upon which they are to return. Mr. Dillard, anything you wish to bring to my attention, sir?
Your Honor, with respect to the next date, what's the date that you selected?
Yes, sir. I indicated 2/18/21 at 9:45 a.m., sir. That's on a Thursday in the month of February. If there's something that works better for you, sir, you can indicate so, and we'll try to adjust it.
That's good for me, Your Honor. Your Honor, do you have can I have your email so that I can file my appearance?
Yes, sir. And here's my clerk. She's going to give you information right now, sir.
Latifah, L-A-T as in Tom, I-F-A-H. .Hunter.
Okay, Latifah, say that again.
Latifah.Hunter. She'll spell that first.
Hunter at 36districtcourt.org.
Yes.
Okay, and Your Honor, if I may say one thing, notification has been given to the tenant regarding the CARES program that was available. That was sent some time back. As of right now, she still has not selected to engage in that, and therefore, as we speak today, she is not eligible unless she makes application to even be considered for any type of deference in the future with respect to the eviction. And I'm saying that simply so this thing is not belabored with delay after delay after delay for her to get involved. The forms were sent to her. If she wanted to get additional compensation with the program, she has not signed the form. She has not returned the form to my client. And so as we talk right now, she's not eligible. If she's going to get eligible, my client is more than willing to have no objection to that. But if we come back next time, Your Honor, I'd like the record to indicate that we've done everything we can do. And so for her to come and get another adjournment at the next hearing, I would ask that not be something that would be considered.
Well, basically what you're asking me for is to deny a subsequent adjournment without knowing what the facts will be at that time. And I think you know what the answer to that is. I will certainly listen very carefully to any issues that are raised at the next hearing, as I must do. We are operating in an environment where the dynamics there are a lot of moving parts, and that is for sure. This litigant is going to talk to a lawyer. That lawyer will be able to give her some information regarding what her rights are and what systems may be available to assist her. And that's why the date is put out at the 18th, although we know that the 2.0 program, where some funds will be made available, that program may not be up and running by that date. But by that date, should have some indication as to exactly what resources might be made available. And it's a good thing that persons have tried to work through some things prior to coming to court. But this is, in fact, the first hearing date, and that's where we start. We start here at the first hearing date.
Okay, actually, I'm sorry. It's actually, Your Honor, I did do the application and I have turned it in. They told me it's 3 weeks wait before someone can get in touch with me. And then when I spoke with a young lady yesterday, she told me that the first set of funds have ran out, that I would have to wait maybe for the second set of funds. So I did do the application.
Your Honor, I told this tenant about this project, this program in October.
Ms. Bell.
What am I supposed to do about my mortgage?
Ms. Bell.
I'm sorry.
No conversation right now.
Let me stop, Mr. Dillard. Let me stop you, Mr. Dillard. Listen, This is an environment that is different from any environment that anybody has dealt with in the history of court. I've been a judge for 28 years, and I've seen nothing like this. And I'm sure Mr. Dillard has been practicing a long time. He's seen nothing like this. Everybody wants their way. Good for you. The fact of the matter is that there is a system in place now that we're walking through, and that is the system that's going to work. I get this all the time. I filed paperwork. No, she did. She filed paperwork. No, they did. The fact of the matter is that you're in court now. One way or the other, at the next hearing, we're going to know exactly what happened. That's where this case starts here. I wish I could go back and say what everybody did before. It's in court now. I wasn't in court. This case wasn't in front of me. It's in front of me now. And so Ms. Hardy will receive, and I think it's a great thing, she'll receive assistance from lawyers that will be able to help her to work through the balance of whatever program is there now. But we know that those initial funds are no longer available. And we also know that there is another program that is coming. And so that's one of the things that the lawyers are helping to occur, is to connect the dots. Because the first program, there are a lot of applications that were left hanging out there, and that program came to an end. Fortunately, we know for certain that there is another program, and we know that program is going to drop somewhere between the middle of February and the middle of March. That's the issue that we're dealing with. And that's why the court is trying to adjourn it. Some cases already have adjourned until March the 10th to deal with this. My hope is that by the 18th of February, we will at least have sufficient information to see which direction this is going in. And if that gives us information on where EDP is, we'll know exactly what the next step is in this process. If for some reason there has been an establishment that there is ineligibility for 2.0, then we'll know that at that time, and then we'll be able to proceed and find our way forward. So that's I've given you the next action date. That's when you're coming back into the Zoom. That doesn't mean that everything is waiting on that. The next step involves the lawyer that is going to become involved in this case in some way that will make contact with Mr. Dillard. So that's going to happen so that they can communicate and keep up with what the status of things is moving forward. All right. So let me see who's going to talk with Ms. Hardy. Ms. Indra, are you prepared to go forward?
Yes, I can talk to the client, Your Honor, but I'm sorry, I just was out of the breakout room. So can I know the case number?
Oh yeah. Or if there's someone else that can do it, I know you. I thought you just lit up, but you just came out from talking to someone else. Who wants to go?
I can, if that would be easier, Indra.
All right. Thank you. Attorney Andrea Enright is going to speak with Ms. Hardy in this matter. The suffix on the case is 9724. This involves property on Normandy Street, 16520 Normandy Street. And so I'm going to send Ms. Hardy to the breakout room with Ms. Enright. And Ms. Enright, Counsel Mr. Dillard, you could inbox or you could chat your information to her and whatever needs to be done so that you all in contact with each other. Right. So Ms. Enright, I believe that I have you in breakout room number number 3.
Not yet.
All right. All right, Ms. Enright, I'll send you to breakout room number 3.
Your Honor, one moment. Attorney Enright, my cell number is 248.
Well, you might not want to put it here. Sir, let me stop. I don't want you to put your cell out here because we're on YouTube Live, Mr. Dillard. So let's just hold on. Let's stand down on that, okay? And let's exchange some information in the chat or something so that we don't have to put it on YouTube.
Your Honor, could I be sent to the breakout room with her? I'll give her my information in there and then come on out.
I am going to advise Ms. Hardy that I'm not saying that I'm representing her at this moment. So we are advising everybody that comes in, Mr. Dillard, and if we represent her, I will get in touch with you.
Okay, that'd be good.
Okay, thank you.
All right. So how are you going to exchange information? Do you want to do that right now in a breakout room, Ms. Enright, and then I'll send Ms. Hardy after?
Sure.
Okay, let's do that. Mr. Dillard, I'm going to send you to 3 and this.
Okay, thank you, Your Honor. And are we free to go at this time?
After you speak in that breakout room, you can go there. And your client is free to go.
Okay, Ms. Bell, you can log off. Call me in about 15 minutes.
Okay.
Mr. Diller. Okay, Mr. Diller, I thought I sent you there. Here we go. Let me get you there now. There you are, sir.
Okay, thank you, Jan.
Thank you, sir. And Ms. Hardy, I'll be sending you there as soon as the attorney on the other side is out of the room, that I'm going to send you to talk.
Okay, thank you.
All right, this is all right, Mr. Abbott, I'm coming to you second. Mr. Gann, you're up now. This is 2034978 Cathedral Venture Limited Partnership versus Yolanda Davis and other occupants of property located at 80 East Hancock, number 1703. The court also calls the suffix 9732. That's Cathedral Venture versus Jesse Johnson and other occupants of property at 80 East Hancock, number 1708. Your appearance regarding those matters, sir. Mr. Gann, you got me? Mr. Gann?
I'm muted. He's on mute.
Yeah, Mr. Gann?
Mr. Gann?
Yeah, he's doing something else. All right, let's go to Mr. We'll come back to Mr. Gann in a moment. Mr. Abbott, I'm calling 20349-736. That's Sound Management Incorporated versus Marcus Williams. The suffix 0740. That's Klein Homes LC versus Angeline Glass and other occupants of property at 18260 Myers. The court calls the suffix 9748. That's VBMB Management Company versus Kendra Reynolds Smith and other occupants of property located at 11300 Long Acre. The last matter, 9748, is set for 3 p.m. Your appearance at this time, counsel, Mr. Abbott.
Yeah. Good afternoon, Judge Coleman. James Abbott for the plaintiff, P26085.
All right, thank you, counsel. And let me see if I have, counsel, are any of these matters subject to any dismissals or anything, sir?
Yes, suffix 740 can be dismissed.
Yes, sir.
And also, if you have it, 744.
You already.
Yeah, I already received the order on 744, so 744 is dismissed. I am now noting the file 0740. That matter is dismissed at this time as well on the request of counsel.
On suffix
yes, sir.
736, I believe I have my client, Mr. Reddy, is on the line with us.
All right, and good afternoon to you, Mr. Reddy.
Good afternoon, Your Honor. How are you today?
All right, good to see you. Do I have on the Zoom Marcus Williams, tenant occupant at the Chapel Street address? Please identify yourself if you're on the Zoom at this time. Marcus Williams on Chapel Street. All right. I know it's just after 2:50. It does appear that Mr. Williams has not appeared on the Zoom. Accordingly, the court, under the administrative order, will grant an adjournment or strike a new court date. This is the first hearing in this matter, and so we're granting a second hearing date in this regard. That date is going to be the 12th of February, 2021, at 9:45 a.m. If the defendant does not appear for the second hearing, the court will entertain at that time a motion for entry of default judgment. That is the 12th of February, 2021 at 9:45 a.m.
Thank you.
Thank you, Your Honor.
Thank you,
Let
sir.
him know that this case right here is the one getting that. This is the wrong, that's not even our case. Somebody put, that's the wrong thing in the file. That is Judge Gary. I don't want him to dismiss his wrong.
Mr. Abbott, this is
350-349, that one, the 350 case, that one is in the wrong file. So that's for Judge Gary.
the suffix 0740. I understand that that's Judge Garrett's case, but you're moving to dismiss that nonetheless, correct?
Well, no, I'm moving to dismiss 9740.
Hello?
Wait a moment, ma'am. I'll be right with you. What did you say, Mr. Abbott?
Case I want to dismiss is 20349-740.
Okay, yeah, this one, we had this wrong then. This one that I had, that belongs to Judge Garrett. That's case is 20350-740. And we're gonna make sure that that case gets to Judge Garrett. That's not our case. That case is not dismissed. All right, Ms. Enright, I'm sending you back and sending Ms. Hardy at this time. All right.
Great, thank you, Your Honor.
Your Honor, could you add me to that court to that breakout room as well, please?
I think you're already there. Well, no, you're right. You got to change it around. You're a step ahead of me, and I don't like that. All right, I'm putting you in 3, Ms. Kakari.
Thank you so much.
And, I'm also sending you now, Ms. Hardy.
Thank you.
Your Honor, I want to.
Just hold on a second, ma'am. There's your notification.
Okay.
All right. So now, ma'am, what is your name?
My name is Tila Caffey. I'm on the case 203497744.
744. Just one moment, ma'am.
I'm moving to dismiss that case.
That was your case, Mr. Abbott?
It is, yes.
Yeah, ma'am. Yeah, that case has been dismissed, ma'am. The plaintiff is not going forward. The case is dismissed.
It's a termination.
Thank you.
It's a termination case where my client took money. We're going to file another lawsuit, but this case has to be dismissed because we took money on a termination case.
All right, very well. Case is dismissed. All right, good day to you, ma'am.
Okay.
All right, and Mr. Abbott, we're waiting a few minutes on that last case, or unless I have a Kendra Reynolds Smith, someone living at Long Acre on the Zoom. If you're on the Zoom, you can say something at this time. So that case is not up until 3 o'clock. Mr. Gann, are you able to hear me now? All right, he's in another courtroom. That's okay. That's okay. We'll wait for you, sir. No problem. All right. And so, Mr. Abbott, we're waiting on the 3 o'clock hour for that last case that you have in front of me. Any questions on other matters, sir?
No, not at all. Actually, I do have a question. Can I dance off to another courtroom and come back?
Yes, sir. Yes, sir.
Thank you.
Go right ahead, sir. We'll pick
Thank
back up, come back. Okay.
All right, bye.
I apologize, Judge, for having to put my finger up like that. I was talking to Judge Millhouse at the moment.
Well, you know, she should get priority over me.
Absolutely. I do love being able to go back and forth, and if you like to see your courtroom, there it is.
Thank you. I'm so inspired now. I've called the suffixes 9728 and 9732. I've called as the plaintiffs are in both matters are Cathedral Venture in the suffix 9728. Yolanda Davis. I've called for Ms. Davis, Marquise Holt, and other occupants at 80 East Hancock, number 1703. I've also called for Jesse Johnson under 9732 and other occupants of property at 80 East Hancock, 1708. I've received no response, and these matters were set on for 2:40 p.m. Counsel, your appearance, sir.
Yes, sir. Steve Gann, P78209, appearing from plaintiff on this case. Actually, on both of these cases. My client is going to be willing to do the 2.0 if these residents want to apply for it. They're definitely hoping that they will do so.
Yes, sir. So what I'm going to do, given that it is the first hearing, I will go ahead and set them over for the 18th of February, 2021. And I'll set them for 9:45 a.m. on that day. We can get to it and see if they will appear. If they don't appear at that time, with respect to both matters, I will entertain a motion for entry of default. All right, sir. So I wish you well. That's done on those matters, and a good day to you, sir.
Judge, Jesse Johnson. Could you repeat the date one more time, Your Honor?
One second, Madam Court Reporter. Mr. Gann, you were saying something, sir?
Would you mind repeating the date one more time, Your Honor? There's some static on the line.
Yes, sir. That is 2/18 at 9:45 a.m.
Thank you so much. You have a safe day.
And likewise to you, sir.
Your Honor?
The court calls. Who's talking to me?
Jesse Johnson.
Yeah, Mr. Johnson, why are you talking to me? Tell me what you want.
That was Mr. Gann's client that you just called. That's what I was trying to tell you.
Okay. All right, Mr. Johnson. So you heard what's going on there, right, sir?
Yes, I did.
All right. I wish you well. We'll see you in the next Zoom, sir.
Okay, thank you so much, Your Honor.
All right, okay. All right, the court calls 20349-712. That's Argo Property Management versus Rhonda Sutton, and occupants of property at 14931 Flanders. The court also calls the suffix 9708. That is Regard Apartment Company LLC versus Delonte Ross. The court calls the suffix 9704. That is Town Square versus Nancy Allison and other occupants of property located at 20559 Motor Drive, number 114A, strike at 11-A4. All right, so in these matters, the attorneys for the respective plaintiffs have not appeared in the Zoom. On 9712, that attorney is Harrison Gala, P number 76452. However, defendant did not appear either. It does appear to be the first hearing on each of these matters. In regard to 9708, the attorney of record is Elizabeth Martin, P number 38124. Defendant did not appear as well in that matter. Regarding the suffix 9704, that's attorney Sidney Katz, P number 51471. Counsel has not appeared in that matter. Defendant Nancy Ellison has not appeared as well. In each of these cases, I am going to set them over for second hearings. The hearing date will be the 18th of February 2021. The hearings in these matters will be at 10 o'clock a.m. On the 18th of February 2021.
Having 12, this one here, you already dismissed this one. Yes,
Is that dismissed?
yeah, didn't have that.
Okay, we all set on that. And if there are dismissals on the other ones, fine, that just closes them out. All right, is that Ms. Kendra Reynolds Smith on my Zoom? Say something if that's you, ma'am.
Yeah.
All right, then good afternoon to you. You live at the property on Long Acre, is that correct, ma'am?
Yeah.
All right. So I called that case. It's BBMB Management Company versus Kendra Reynolds Smith, an occupants of property at 11300 Long Acre. That's 2349748. Mr. James Abbott, the attorney for the plaintiff company, did enter his appearance. He's in another courtroom at this time. Miss Reynolds Smith, have you had an opportunity to speak with a lawyer regarding the matter that you have before the court, ma'am?
No, I was trying to find one, but couldn't.
All right. All right. So I'm going to set you up to talk with a lawyer that will be able to give you some information regarding this matter and go over what your rights are in this case. Also, what I'm going to do at this time is I'm going to set the case for a new date under Michigan's Supreme Court emergency order, administrative order, I should say. I have to set a second date. That date's going to be the 18th of February, 2021. And that's going to be at 9:45 a.m. 2/18/21 at 9:45 a.m. That's the date that you're going to use to Zoom back in. You'll come back to using the same information that you used today to come back into the Zoom. Now, right now, I'm going to give you a lawyer to talk to at no charge to you, and you'll be able to go over your rights and get some direction regarding this case. Okay.
All right. Thank you.
All right, so what's going to happen is I'm going to give you a notification to go into a breakout room. When you go into that breakout room, you will meet and talk with legal counsel that can speak to you regarding your case. All right, so let me find out now who's available to speak with Miss Kendra Reynolds Smith, living at Long Acre and under file number 9748. Somebody will speak up in a moment.
Your Honor, I'm available. Josh Ronnebaum from Lakeshore Legal Aid.
All right, thank you, Mr. Rombaum. Attorney Rombaum is going to speak with you, ma'am, and I'm therefore sending you to breakout room number 2. You're going to receive a notification right now for breakout room number 2, and the attorney is going to meet you there. So click on, and he'll meet you there.
All right, thank you.
Thank you. And sir, you should be able to go back. And that is it, unless someone has something that I missed that I need to cover. I don't have any other files for this afternoon. Looks like we've completed files that we have.
I did submit that dismissal on the case, so Ms. Hunter should have it to be signed, Your Honor.
Okay, all right. Which case she says?
That was DJ, Demetria DJ 760, I think. Let me make sure. 7060.
All right, she's checking on that and pulling it up now. I see where it's coming from. Thank you. I'm signing that now. Thank you.
Thank you, Your Honor.
Mr. Abbott, I just called the last matter. The defendant did in fact appear, and she is in a breakout room right now, speaking with Attorney Rombaum. And that is Ms. Kendra. Can't remember the last name, but she appeared, and I set the next action date for the 18th of February at 9:45 a.m.
Kendra Reynolds.
Kendra Reynolds.
Thank you.
All right, thank you, sir.
I'd be interested in talking to, who's the defense counsel on that?
Mr. Rombaum, he's with Lakeshore, is he not, or is? Yes, he's with Lakeshore. I should say Andrea Enright is here. She could connect you. His name is Joshua Ronbaum. I think he's kind of new here, right?
He was working in a different county, but now he's doing some work in Detroit. So yeah.
Andrea,
yeah, he wanted real work, so he came.
Correct.
Speaking of real work, Andrea, can we talk on this matter, or?
Yeah, sure. I'm not on that one, but you want something else?
No, on the Reynolds Smith case.
Yeah, he's talking to her right now, so I can send you his info.
Yeah, and or you could, I've got to keep the Zoom open until he's done talking in that in the breakout room. So, I'm sorry.
I'll be back. If you could, Andrea, give him my number.
Yep, I can do that.
313-967-1000.
Okay, doke.
Appreciate it. Go blue.
Go green. That's Jim and I's eternal greeting.
Yeah. Oh yeah, for sure. My MBA is Michigan State, and my daughter undergrad is Michigan State, and my second daughter undergrad is Michigan State. So
I feel like we're solidly in the go green category also.
I would beg to differ.
I knew there had to be something else going on. My
Correct.
late wife was U of M. So we, the whole house was U of M. And I think that my younger daughter went to state just because her mom went to Michigan. So that's kind of how the tide got turned.
Those things do tend to work out that way. Yes. You're still streaming if you wanted to not, just FYI.